A Fulton County judge is expected to rule on a mistrial motion in the YSL RICO case that we've been following here on Atlanta News First for nearly a year since witness testimony began. It comes after information was brought in front of a jury that they apparently were not supposed to hear. The jury was excused while Fulton County Judge Paige Whitaker weighed the request for mistrial, ultimately canceling court for the day yesterday and again today. We have a lot to get into, but for more on how we got here and where we are right now, I want to send it over to Atlanta News First reporter Sarah Hammond.
The judge in this case had to consider if she would grant a mistrial after the jury heard part of a social media post with a piece of information that the defense says was supposed to have been redacted. A witness on the stand Wednesday read the words #FreeQuay. The words were redacted on the screen, but not on the paper he was given. It references when co-defendant Marquavius Huey was previously in jail. Huey's attorneys argue because of the slip, now the jury knows the co-defendant's history. Judge Paige Whitaker denied the defense's motions for a mistrial with prejudice. That would mean the case would end and could not be brought back to court. However, she said she would consider a request for a mistrial without prejudice.
That means, of course, that the state would be free to try every one of y'all again.
Judge Whitaker scolded the prosecutors for the mistake, saying it could waste the year-long process they've already started.
I don't honestly really care what the poster was referencing. What I'm trying to do is fix your sloppiness, so that everybody won't have wasted, 10, 12 months of their lives in this trial.
This trial began almost a year ago, and defense attorneys have repeatedly brought up concerns about the length of this trial. But Fulton County prosecutors still have 100 witnesses to call. At the Fulton County Courthouse, I'm Sarah Hammond for Atlanta News First.
All right, so we have a lot to break down for you. Some of you hearing about this for the very first time. To help me explain that, I want to welcome an Atlanta News First Plus favorite, Attorney Josh Schiffer. Thank you so much for coming. Now, you are not directly tied to this trial actively, but you have been following it, as many, not just here in Georgia, but really around the country have been. This is a trial that has taken national and international attention, involving a prominent Atlanta rapper and 6 co-defendants. And now we're here with a very frustrated judge and a lot of questions on whether we're going to see this trial continue. Explain to me exactly what happened yesterday.
This is the best popcorn trial that has ever happened. The longest criminal trial in Georgia history. We have all the big players and a celebrities involved. One of our homegrown most famous entertainers is battling literally for his life in the longest and most complex prosecution in Georgia history. So what happened yesterday? Well, just catch people up. Y'all know we're on this second judge, and there's been a lot of fighting over what evidence was going to come in and what evidence was going to be restricted or excluded. That started with Judge Glanville. It's continued with Judge Paige Reese Whitaker, who is currently the elected Superior Court judge trying this case, or at least trying to try this case. One of her outtakes yesterday involved her commenting on how she's trying to save this case from being wasted 12 or 18 months because of sloppiness, and that's because of the testimony that we are hearing. Previously, we have had multiple instances where witnesses, almost exclusively state witnesses, have testified to information that they should have been told by the DA's office they were not supposed to get into. That's part of basic witness preparation. There are going to be issues that are excluded by the judge or prevented by the rules of criminal litigation from being introduced in front of a jury, with the remedy being, if those rules are broken, that something has to happen with the case, including dismissals. If the cat gets out of the bag, if the bell gets rung, you can't put those facts back together in a way that preserves the defendant's constitutional rights. And that's really where the analysis is. Are the constitutional rights of the defendants being met when there's this unsolicited testimony? So what happened yesterday? An officer, kind of in summary, basically referenced somebody's prison sentence in a way that wasn't admissible. And a juror knowing, or all of the jurors knowing about someone being previously convicted or incarcerated. That's bad character evidence, and it's not appropriate for the jury to hear because it would impugn their ability to make an independent judgment. Now, most of the time, these kind of simple mistakes are fixed with a curative instruction. Oftentimes, the jury doesn't even understand what happened because the discussion about all this happens outside their presence. When there is an issue, like we saw yesterday, of a witness testifying to something that shouldn't be out in the wild, the judge kicks everybody out of the court and talks with the lawyers, and they figure out what they're going to do next. Yesterday, we saw an extensive interchange between Judge Paige, Reese, Whitaker, the state, and the defense over this unexpected, unsolicited slip-up by a state witness, but it still had the effect of wrongfully providing information of bad character in an incorrect and unconstitutional and wrongful manner to the jury. The defense immediately moved for mistrials, and during that discussion, it became very clear Judge Paige, Reese, Whitaker would not grant at that moment a mistrial with prejudice, and with prejudice means that the state can't come back and retry the case. It's dismissed. The state doesn't get another bite at the apple. Or what she really looked to be leaning in on was the possibility of a mistrial without prejudice. That could and would preserve District Attorney Fani Willis's ability to bring back charges against Young Thug and the other co-defendants. There's about 6 or 7 in this trial, and then, of course, there are a few that have been removed. They've been severed from this trial, and, of course, others have already pled guilty. In fact, we've got another probation revocation coming up due to one of the state's witnesses in this trial getting arrested and violating probation. So what happened after Judge Whitaker stopped yesterday? Because when she stopped, she basically said, hey, y'all, I got to think about this. She asked the defense what their opinion would be on a dismissal or mistrial, rather, without prejudice, thereby preserving the state's ability to come back. And the defense had a lot of thoughts about that. There are wins with a mistrial of that nature, but then there are big losses as well. Continuing exposure for all of the co-defendants, and each co-defendant may face a different form or flavor of criminal exposure with a mistrial. For example, one of the big questions is this speedy trial. There is a speedy trial demand that's been filed, and there are legitimate academic questions of whether there would be a possible second trial or whether a second trial would automatically violate the listed speedy trial. Tough stuff. Paige Reese Whitaker then met, or sorry, not Paige Reese Whitaker, DA Fani Willis then met with the defense teams over the last day. During this, Miss Willis has also been celebrating her 53rd birthday with a whole bunch of events, so she's been busy, but we do know that she sat and met with the defense teams yesterday. Those conversations are continuing today, specifically one-on-one conversations between the prosecution and the defense, and the judge has come out and actually canceled court for today. There was a brief appearance first thing in the morning, but everybody has now been sent back to jail, back to home, as we wait and see what's happening in the background. And no one knows exactly what the next step is.
My big question, I think, we've seen some of the comments from our own viewers saying, what's so different about this mistrial? There have been countless, dozens of mistrial motion requests from the defense. Yeah. What is it about this one that is causing Judge Whitaker to take a pause for now going to be the second day?
It's the cumulative nature of what's happened. Some of the mistrials brought up earlier were less, I don't want to say meaningful or serious, but they were for more minor transgressions. Issues that it was relatively straightforward for Judge Whitaker to say, all right, you've made your record, we're going to keep going. No, denied. And we've seen more aggressive ones. There have been formally filed motions for a mistrial. Brian Steele had one that was particularly lengthy. And those are all attached to the record. They are all subject to review by an appellate court, depending on what happens with this case. So what makes this one different? Well, a number of things. It involved character evidence, and it's wrongful character evidence. It's not character evidence that there's a question about, really. You're not allowed to talk about the prior bad acts and convictions of people if it is prohibited. And that information permanently changes the output or the outlook and the perspective of jurors sitting in judgment on this case. If you've spoiled your jurors, can you continue a trial? This is particularly interesting as well because of the idea that it would be without prejudice. The defense has been asking Judge Whitaker for a mistrial with prejudice basically since she took over, and certainly many before Judge Glanville. That's because with prejudice prohibits the state from continuing their quest to convict all of these co-defendants. So it's a big win for the defense. Without prejudice, that's an absolutely different set of calculus. What would a retrial look like? What kind of other dispositions are possible? What's the status of the defendants if we do have another trial? These gentlemen have been sitting in jail without bond for years. And in fact, this is particularly expensive because some of them have to be housed differently and separately from other inmates. And in fact, Fulton County is cutting a big check to Cobb County to host some of these individuals. So the idea of what the state would do with a potential to retry the case is very valid. Would Fonnie Willis continue to dedicate the resources and assets towards this one case given the backlog? I was just down in Fulton County yesterday. The first 10 or 15 cases were all big murders, really complicated, really important cases that are oftentimes 1, 2, 3, 4 years old, and they're not getting disposed of because Fulton County's been so preoccupied with some of these high-level, big import cases. And so Fonnie Willis has to do a good job balancing the rest of her job duties. She also has to look at where this case stands. She's on her second judge. There are a host of appellate issues. It is clear from anybody watching the case that the state and the court have a little bit of a contentious relationship with some downright scandalous commentary coming from the judges regarding the performances of Chief Senior ADA Adrian Love, Simone Hilton. Now Mr. Abate has been dragged in. We've seen this revolving cast of prosecutors, many of whom have appeared unprepared and have incurred the wrath of a judge who is angry openly at the speed and process of this trial. So Fonnie Willis needs to look and see, reassess what the strengths of her cases are, as well as figure out, is there an escape route? Is there a pathway to preserve her mandate while also disposing of the case? So we reverse roles with the defense. What do you think they would want in order to end this case? Is Brian Steele, chief lawyer for Young Thug, going to demand a complete exoneration for his client? Mr. Young Thug doesn't have a record. He has nothing. This is the only thing that is, potentially on his criminal record. So would he accept a lesser charge? Would he accept first offender, conditional discharge? Would he perform some sort of diversion? Very often diversion, which is a diversion of prosecution through completing some of other activities. Would diversion be an appropriate result for the alleged allegations? And that really gets explosive because of his fame and notoriety. He's someone who brings to the table a lot more stuff than your average defendant. The other co-defendants, some of whom are already sentenced to life in prison. What is their impetus for taking a deal versus make them prove it? And would Fonnie Willis want to dedicate those time and resources to go convict people who are already serving substantial sentences or played a lesser role? This is an opportunity for Ms. Willis to leverage the various co-defendants against each other, as she has done previously. We've actually seen the probation revocation from Monk Tunk when he violated the terms of his promises to testify openly and truthfully. When he did not do that, he was revoked. That's the process that's still going on. And Adrian Love could turn around and walk up to one of the co-defendants and say, hey, we'll dismiss it all, let you go. You get out of jail. No harm, no foul. You just have to say this or do that. That's a tempting offer, no matter how important the principle supporting these gentlemen appears to be right now.
Well, let me ask you this. You are a criminal defense attorney, not tied to the YSL trial, but a practicing criminal defense attorney here in Atlanta. The state's position right now, not looking very good in the judge's eyes, herself calling them sloppy was the word she used. Now I'm reading some of the comments we're getting as people are listening to you and trying to wrap their heads around this latest development. There was a point where she criticized the state and how they're handling this, saying that she is going to have to fix this mess. there's a misunderstanding possibly that whether she is trying to help the state in this way or whether she's just trying to hold a fair trial here.
The optics of that statement are absolutely horrible. Every lawyer I know perked up whenever that came across the airwaves because it's absolutely improper in all way for a judge to show some sort of favor or support to one side over another. While this would absolutely be part of an appeals case, more importantly, it advises the stakeholders of a problem that they're looking at right now. The case changed when she came out and made that statement, and if you slow it down and listen, you can almost see her recognize that she is speaking in a way that endangers the project they are all working on. Now, when I step back and look at the whole totality of the circumstances, I don't believe that one comment rises to a level that would invalidate or require dismissal, but it's the cumulative nature of this and whether the defense could show that there's a pattern of behavior of favoritism, something that was strongly alleged against former YSL trial court judge Earl Glanville. There was extensive record creation of Glanville's alleged favoritism of the state, and in fact that comes out in the appeal that we saw this week, where Brian Steele, when Judge Glanville held attorney Brian Steele in contempt, the Georgia Supreme Court came back and said specifically that once Earl Glanville had inserted himself into the dispute, Mr. Steele deserved a review by an independent jurist, not Judge Glanville, because Judge Glanville had gotten personally involved. Paige Reese Whitaker is looking at similar allegations and accusations. Her commentary that she was trying to fix the case easily construed to show favoritism to the state, even though I believe in totality her intent was to save the case and protect the case's independence and legitimacy without favor to one side or the other. But it very clearly looked terrible. If I'm a defendant, I'm screaming bloody murder at that point, and it would give me cause, if I'm Fani Willis, to consider more aggressively dispositions that don't include finishing this trial. Fani Willis has the ability to basically do whatever she wants with this case. She can continue trying it. She can continue to dedicate assets and resources to the prosecution, and she absolutely can follow it all the way through to verdict and appeal and anything else. Or she can make different decisions. She's the highest constitutional officer involved in the judicial branch in Fulton County, and it's 100% her call whether she wants to pursue the case or not. She might have some egg on her face if she drops it, but I don't think that's going to happen. Much more as she's going to find some way to end the process that preserves as much of her mandate and support as possible while also being agreeable to the defense. We just don't know what that looks like. Would a young thug be interested in any disposition that's not a complete exoneration and basically an apology, which I don't think that's ever going to happen from Fani Willis. The personal conflict between the defense attorneys and the state, never seen anything quite as vicious. It's so bad that Mr. Steele has stated on the record he will not discuss the case with DA Adrian Love and only will discuss it with DA Willis because the decline and the destruction of the professional relationship between the state and the defense. So the meetings that happened last night and this morning, that's huge. They could literally be walking out with a full resolution of all charges, and we could have seen the last trial day of YSL.
Now, I want to put the viewers and yourself in Young Thug's shoes here for a moment. He has been jailed since May of 2022. This, for him, has been a lifetime, essentially. So let's talk about that. I feel like there was a moment of hope for the defense when Judge Glanville was recused from the case or taken off from overseeing this court, but they survived a mistrial then. Is there any hope for the state to survive this mistrial motion, or is it looking a little more optimistic for the defense and their mission to clear Young Thug and co-defendants of all of this, all of these charges that you were mentioning?
Stepping back right now, the advantage would appear to be in the defense, because their goal is to not have a complete trial and to prevent future prosecution of their clients. So they have a lot of possibilities on the table. However, Judge Whitaker is the one that makes the call on the mistrial. Sure, you can always go to the Court of Appeals later. But right now, the decision that matters, it's really Paige Reese Whitaker when it comes to the mistrial. Now, when it comes to other ways of disposing of the case, and I'm just getting absolute breaking news right now, just handed to me by one of the journalists here, DeMonte Kendrick, one of the co-defendants, has been meeting with Fani Willis regarding a plea deal. And that's absolutely what we would expect, that Fani Willis is trying to make the deals to end her office's exposure in the case while trying to obtain some sort of substantive justice. She does hold an upper hand in that everybody has to sit in jail as long as she wants to keep putting them on trial. So this is a huge development, that plea negotiations are underway. They are actively being discussed. What does that look like? Who knows? We're talking about RICO. We're talking about a lifetime of incarceration if convicted. So when you're negotiating one of these reductions, is it to a specific charge? Is it to some diversion program? Fulton County has formal diversion and informal diversion. Georgia also has a number of ways to dispose of cases that sound like pleas, act like pleas, but aren't actually pleas. Things like first offender. First offender in Georgia is a plea and abatement, where you plea, you do the sentence, but the judge never filed it. They stuck it in their side box. And when you're done with your case, if you successfully complete first offender, they pull all that paperwork out of the basket, tear it up, and you're allowed to say you've never been convicted. That's one of the giant benefits of first offender, which are available for most charges. So if the most important thing is your record, first offender is a great option. That could be on the table. Same with conditional discharge, which is first offender in Georgia for drugs. There's reductions into either specific charges related to specific actions or what we call garbage disposal charges, which are charges that can encompass a huge amount of different behaviors, result in an adjudication of guilt without everybody having to agree, and a sentence. And that sentence could be anything including straight probation, credit for time served. These gentlemen have accrued enormous credit on their cases because you get day-for-day credit for your pretrial detention. So you could look at sentences that include service of 1, 2, 3, 4, 5 years or more, and these gentlemen would be qualified for immediate release. There are so many variables that are hard to determine, and on top of all that, Fani Willis wants to keep getting elected. Fani Willis has a big future, and she wants the big win because of the pillaring she's been receiving from the public based on how she's managed this case.
Not to forget, she's actively running for re-election, and that is less than 2 weeks away now. I know we can talk all day about this. There's so much to get into.
Really, y'all, this is as exciting as it gets on so many levels. Not just the celebrity and the salaciousness and the crime and all that. Academically, these are some of the finest lawyers and the highest level of academic competition that we ever see in the criminal universe.
I couldn't have said that better myself. Josh Schiffer, Atlanta attorney, you have been following this trial closely, so I want to ask what your predictions are. What happens next when we see that courtroom shot come back on and everybody tunes in to watch what Judge Whitaker has to say?
The number one thing is I think we've seen the last act of trial day in YSL. I don't believe that continuing the trial benefits or serves anybody's interest. The disposition, much more questionable because Fani Willis does have some very strong and hard facts against some of these defendants, and the defendants have different mechanics and different equations within themselves about what their risks and rewards are. Young Thug has the most, if you want to say it like that, at risk because of the potential for his earnings in the future, his reputation in and among the music community. Him taking a plea has a certain impact. Him being dismissed has a certain impact. I could see very much advising my client, hey, let's stop fighting the past, move forward. And if the right offer was on the table with credit, without having to do anything big in the future, without any impact, with freedom involved, it's very hard to stand on principle and say, no, I want what I deserve, and that means I'm going to spend time in prison or jail to get. Wow. That's a tough discussion, and it's something every criminal defense attorney talks about their clients daily. Hey, Josh, I didn't do it. Well, sir, I know that. And if you want to go in front of a trial, we can do that. But trial is a risk. You could always lose. Great lawyers lose trials regularly. A trial is a risk assessment. So it's not just, do you want to go to trial? I want to win. There are so many different aspects involved.
With that, I do want to point folks to our website, atlantanewsfirst.com. You can also access this through the free Atlanta News First app. We have put out a full explanation and breakdown for you. If you are hearing about this for the first time, or maybe you haven't been following over the past year plus of every single shocking development to come out of this, we have broken it down for you. And right below, you can get videos like these and more on the latest of what's happening. Every time that trial camera pops back up, we go live right here on Atlanta News First Plus, and we have that for you right here under the tab Young Thug Trial. So download the Atlanta News First app. We'll send major push alert notifications about this trial directly to your phone. Josh Schiffer, I can't thank you enough for joining us here today. I just want to make sure that if folks wanted to connect with you because you are a practicing attorney here in Atlanta, they can. What's the best way to reach you?
Just Google my name, Joshua Schiffer. I am not related to the beautiful model from the 90s. I'm the other Schiffer. And if you Google that Schiffer and lawyer, you will eventually find me. And please reach out. I love talking with people.
With that, we are going to have a lot more on this trial following every single development to come. Right now, no word on when Judge Whitaker will resume court as she's weighing this mistrial motion. Our Atlanta News First reporter, Brittany Ford, will have more later on this afternoon on Atlanta News First. Make sure you tune in.